Currently, grant any date, my lord. It's a land acquisition matter, the poor agriculturists are waiting for. Any convenient date, my lord.
No, you must have got already compensation in this.
My lord.
High Court must have already granted you something.
No, my lord, actually, there is a delay for granting this, applying for a reference, and that is the main issue pending before your lord, my lord.
Vacation के बाद से.
It's-
After vacation.
You lordships were kind enough to list this matter on 24. However, because of the partner matter on arbitration, this matter could not be taken up on that day. It's related to the admission of medical students in a medical college. And couple of 14 and 20 students have been admitted pursuant to the interim order passed by the Honorable High Court. However, those students have not been dealt with in the impugn order.
Okay.
Your Lordship, may I request to list on Friday or Monday
Next week.
much on miscellaneous day, Your Lordship.
Yes.
Please, my lords. My lords, this is a bail matter. My lords was pleased to issue the notice on 14/11/2024. Since then, the matter has not been listed. Kindly list the matter before on Friday or Tuesday.
Yes, next one.
My lords, the date is
They will give you the date.
published.
Yes, my lord, this is a bail matter. He's been inside for more than 4.5 years. Notice was issued on 15th April. It's not come up.
4.5 years.
He's been inside.
What is the offense?
My lord, 302.
1.5 years is not.
My lord, co-accused playing the identical role has been granted bail on 15th April by this very court.
Next week, maybe.
Keep your hands.
With my lord's kind minutes, permit to make registered mentioning minutes. Civil appeal from actual minutes of 2021 where the respondents. There is a stay against us, accumulated dues towards us are more than 400 crores with us. And my lords have ordered it should be expedited and it's still showing weekly list and it's not been listed once.
To say after vacation. Mention it after vacation.
Within the batch of matter, my lords is specifically given a direction that is still available. I came on board, but now it is not showing them. My lords in the past, the order gets listed on every other basis. It came in the list, now it has been deleted.
No, because now this side of the vacation, it's not possible.
I completely calm on this of the in which state we post for the.
You mention it after vacation.
Sure. Such a document I mentioned was a reverse IRP matter was pertaining to a housing project. The lordships have repeatedly given them time about 18 months, 6 months extended. Contempt is pending. Yesterday it was listed.
I Grace.
No, not the IRP. Which was that? Which one was that? Orient Galaxy, Noida, there's some Kakinat Chupla, some person. The promoter comes in here for the first time. Entire proceedings there have been stayed. 3 years here in this court. We would have gotten by there as the home buyers for the NCLT and the incline. So that is the problem, and one after the other, the timelines that your lordships have given, they have been repeatedly breached. So we filed a contempt petition also, that is also pending. Even if it is remanded back to the NCLT.
I mention it after vacation because now there are hardly 2-3 weeks. So last week maybe a miscommunication.
I understand. Very well, in the second week, July, if your lordship could.
With my lord's kind.
Let's act one also go after vacation.
With my lord's kind minutes. On 5th minutes, my lords gave an order. There is an error in that order.
There should be some rationing for mentioning by senior partner.
There is a small correction in the order. My lords gave words on 5th.
I'm thinking about following my Bombay practice.
Let him mention, there's no issue.
I think after 14th, I may consider that.
Until 14th, I will mention.
And you are party to those.
Yes. Small correction minutes in the order of my lords. My lords have stayed the proceedings, instead stayed the judgment, which is a dismissal. That's why my lords nothing transfer.
Correction.
Item 1, whether your lordship may have it after vacation.
What is it about?
That's the Karnataka matter. Bangalore.
That land matter.
Yes. The solicitor called me up yesterday.
Yeah.
Saying that, can you request?
It's at HMT and all that.
Yes. No, your solicitor rang me up and said that, please take a date. That if it's correct, then why you said?
But if the solicitor has agreed for an adjournment and if both of them have agreed for a,
But he has asked, Malaj, and I have agreed.
But I have to on behalf of the solicitor, I'm for HMT. Perhaps both councils were busy with some other matter.
But don't give reasons for that.
if there is an agreement, there is an agreement.
There's an agreement, it's not only at the BS of Mr. Mehta, that's what I want to clarify.
Don't say these things without knowing the conversation. Anyway,
Are you privy to what happened between
Yes,
Mr.
exactly. Why are you
Civil
going
and
into
Mr.
all
Mehta? Yes,
Having
after
after
vacation.
vacation.
Lordship, may I mention an MBBS admission matter? It was listed yesterday, unfortunately, it didn't reach. The exams are over. The results are scheduled to be announced in mid-June. And by the time the court reopens, the counseling will probably be over. So would your Lordship consider posting it on any date? The reason we are aggrieved is there is a stay of the High Court order, because of which we will not get the benefit even this year.
ठीक है, दे देना vacation के पहले.
My lords,
I am so grateful.
may I mention item 33, my lord, all that I am requesting is not to be taken up today.
What is it about?
It's about retrenchment of mining workers in Goa.
Ill treatment of mining workers.
Yes, retrenchment of mining workers that come up last.
Retrenchment.
I'm requesting it to be taken up next week. Just not.
Who is for the other side?
I have given the petition.
So, Narkat यहाँ पे. ठीक. After next week, दे देना.
Item 13.
This comes to your lordships after notice. Your lordship had noticed that I had undergone 5 years, 8 months. There are no antecedents, the conduct is fine. And the appeal is of 2022. Lordship had issued notice with this.
Yes, who is for the state?
The trial court members has mainly relied upon the last seen evidence and the dying declaration that was recorded. Very specific laws even in the dying declaration.
Where is the dying declaration?
It's not on record, but the trial court discusses it at page 100. The lordship says para 42. Agree with you?
Yes.
Reported by PW 5 minutes. He was in a fit condition to execute. Fitness certificate was given by PW 30. That's also discussed.
How many days you have been inside?
Almost 6 years, it was 5 years, 8 months.
5 years, 9 months.
So as far as.
But then the dying declaration clearly implicates you.
Yes, you kindly see this. Now, what the Canceel says is that the dying declaration is recorded in nobody's name. In para 47, please see 106, 105, page 105, para 47. All the family members of the deceased are present at the time of recording of the dying declaration. That's point number 1. Number 2, Mills, at the time of the MLC, which is at page 57 and at 63, read with 63, both the doctor who examined the victim and the doctor say that I brought the deceased to the hospital, and she said that this was all due to burn injuries. She didn't name me at page 57.
So you should have placed the dying declaration on record.
I'll file it. I'm sorry. We'll file it. We'll file it.
We learned to the petitioner. 6 time to place dying declaration on record. Stand out when? 2 weeks? Or after vacation? When do you want?
Put the vacation.
2 weeks.
Grateful.
I am very correspondent to this number 2 minus.
Who is the petitioner?
My lords, I am for the petitioner. May please, my lords. My lords, I am for the petitioner. My lords, I'll just seek for a short passover. My lords, I'll be there before my lords. Give me just a short passover, my lords, up to 12 minutes if possible.
Oh. Also,
Highly obliged, my lords. Highly obliged. Highly obliged, my lords.
Item number 46. Your Lordship, in this case, the petitioner has cleared PPT. Your Lordship, he wants admission in general medicine, and there is one seat vacant in the college of respondent. Your Lordship, to that. And Your Lordship, that seat is allotted to one candidate.
please see the order, madam. At page 1.
Mentioned there, withdrawn, but in fact, petitioner has not withdrawn.
Go and file a review.
The petitioner informed that order was passed by the High Court that we allow you to withdraw and take alternative remedy. But he neither counsel nor the petitioner.
Go and file a review then.
Then there will be hardly any time left.
No, we can't enter in such.
Permit me to file a review.
The learned counsel for the petitioner is liberty to withdraw the appeal. It's liberty to file a review petition before the High Court.
Okay.
I appear on K8, my lords.
Let's. There are, all that we want, there are 1,500 students who are to take the exam. But if they are not able to take the exam, they will lose for this, diploma. So that's all we want is for the moment for us, notice on that issue. Then your lordships can look at the other issue.
You are happy for whom?
The PI petitioner before the High Court.
It's 20. Well, what happened was that the show cause notice was given to us, did not give any material.
Was it at any point of time listed before me in the High Court?
Yes. We'll find out.
Just examine because whether at some point of time.
Yes, we'll examine. Sure. You're also going to then have it on Friday.
Yes, sir.
Friday, Manoj, you're also going to then have it. We'll examine it in the meantime. You keep that.
This is the matter I mentioned the other day when it could not come. Means with your lordship, kindly just state an order, Manoj, of 6th of May of your lordship, Manoj. 6th of May, 24.
The matter can be heard finally. We are ready. Because if he wants that IA to be taken up, then I need to file a reply to it. Then it could be taken up on Monday or Wednesday.
And may I just take 2 minutes? The 6th of May, your lordship has minutes?
Yes.
Manoj, the second paragraph, senior counsel for the respondent submits that by order of 14th December, this court has granted stay of the impugned order. However, there is every likelihood of the petitioner withdrawing the amount. In such a situation, it will be difficult for the respondent to receive.
Not in the.
This is 6th of May, Manoj. I have copies here. May I hand over a copy?
Yes.
But may I file a reply? Not to be taken up on Wednesday. Nothing good to happen till then.
Then we should notice that. 6th of May, first month.
All right, issue notice on the IA order. I'll file a reply.
May I just read the order if they don't mind? So then the page over. There is every likelihood of the petitioner withdrawing the amount. In such a situation, it will be difficult for respondent to receive the said amount once it changes hands. He therefore prays for stay of the withdrawal of the petitioner by the petitioner also. So senior counsel appearing for the petitioner fairly states that in order to secure the interest of the respondent, petitioner is willing to withdraw the amount and deposit the alleged share of 11.33% of the respondent number 1 in this court. He however submits that the petitioner would do so after deducting taxes expenditure incurred upon receiving the said amount. We find that the interest of justice would be met by permitting the petitioner to withdraw the amount. However, the petitioner shall deposit 11.33 minus taxes paid in this court, which shall be kept in an interest-bearing account initially for a period of 6 months. Same shall be done so and so. Insofar as expenses are concerned, we will consider passing the order at the time of hearing the matter. Now, let's kindly come to 22nd January 25 order, which is here, 22nd of January. Senior counsel appearing for petitioner states that petitioner has already paid the amount of 6.53 to the brother of the petitioner, and he has no objection that the said amount is paid to the respondent and pleader. That's the one I represent, Mr. Anil Kumar. It is stated that both the brothers have identical share. We therefore direct the registry to issue demand drafts also. For the rest of the matter, list this matter on 19th March. Now, let's just take for a moment, their affidavit of 20th of January 25. 20th of January 25 is an affidavit filed by the petitioner LLP. 20th of January. Now, your Lordship had asked them to place the expenses which have been incurred. And in this affidavit, if your Lordship will take page 9 of this affidavit, they've given the detail of the expenses they've incurred. And while my amount has been reduced from 11.40 crores to 6.53. Page 9, your Lordship may kindly have first. Where your Lordship may just notice, I'm not going to go into detail. At 3.4, outflows, mentions in the chart number 1 in the middle of the page, legal professional 9.37 crores, other expenses mentioned above totaling 12 crores 42 lakhs. Then at the bottom, the bottom chart, 3.8.3, total cash and cash equivalent available during 3rd June 24 to 31st July was 113 crores odd. Now turn the page over, So they got 113 crores from this land, from the LAO, in the reference proceeding. Now, they say outflows 3.9.1 during the period 3rd June 24 to 31st July. Please see, in the chart, legal expenses 3.73 crores in less than 2 months with no hearing here, 3.73. And then the chart below that, repayment of loans from partners 12.69 crores, repayment of loans also, interest and paid on loan 7.47 crores, totaling 20 odd crores. I will show these were interest-free loans given to partners where they've given about 8-9 crores in interest. Be that as it may, even after adjusting all this expenditure and accepting it, all the expenditure works out to a total amount of 24.2 crores, which when adjusted in my share of 11.33 would still entitle me to 8 odd crores. And they're given 6.53. First of all, this expenditure is incorrect. This is one part. The other is, after the 113 crores received from the reference court, today, in my IA, I pointed out to your Lordship, the Honorable High Court has issued a direction and now issued contempt notices for compliance by 13th May, which is day after, that they have to pay 354 crores the government has to pay. So what I'm submitting to your Lordship is, the way they have deposited before your Lordship, they have asked that the entire payment be made to them. The way your Lordship, 100 odd crores, asked my interest to be secured. Now this 354 crores is coming to them by a direction of the Honorable High Court, pursuant to the writ petition before the Honorable High Court. So that your Lordship will find in my IA, in my IA, which is 110729. So, first of all, they make expenses completely exaggerated, 3 odd crores to lawyers in 2 months when there is not a single hearing in this court. 3.74 crores. But be that as it may, even adjusting that, my share will come to more than 2 crores more than what they've given. Now, in any case, there is another 354 crores which is going to come. In this IA, your Lordship will find at page 63.
Yes. We'll hear the revision. We'll hear the.
My only concern is, like on the earlier date of 6th of May, your Lordship asked them to secure my money, my 11.33. That because the High Court has asked the government to pay 354 crores by 13th of May.
Who?
The government is to pay them, the LLP. My request is, let my share pro rata be deposited here, and then your Lordship may hear it on a convenient day. And your Lordship may give notice to them on my IA. And I will show to your Lordship that they have 3.74 crores legal expenses in less than 2 months with no hearing before this Honorable Court. Interest to partners of 10 crores on an interest-free account or interest-free loan in a LLP which is admittedly doing no business.
Very application which is filed before the High Court. The case of jobbing, what does it?
Not at all. I next stand here.
But we have incurred expenses. We have issued an arbitration notice.
Your office, going to execution of orders here, we already started for the matters pending. Here we should notice for the.
We'll vacate the stay. We'll vacate the stay. No, if you are not agreeable, we'll vacate the stay. Post the matter after vacation, the interim relief granted is vacated.
There's a little problem in that. What has happened is now what will happen is they will still take the money. That 354 crores should be deposited in port minutes, because otherwise this additional money is not this list for your worship. It is 13th May is the date. The Honorable High Court has directed deposited by 13th, otherwise contempt, and that's the last opportunity. So let that be secure. That's all. Let that be secure. I've said so in my arguments.
May I say?
Yes.
Sorry. Not your lordships by an order of 4th November, I have already said that all these applications will be considered at the stage of hearing of the.
We'll hear it right now.
That's what I'm saying.
Proceed then.
Yes.
That's what I'm saying.
Proceed on merit.
That's right.
Yes.
Proceed on merit.
So may I place my arguments first?
If it is to be heard in the minutes, then what is the question of hearing an argument?
The main matter, I will just say one sentence. Insofar as the main matter is concerned, issue was under Order 21 Rule.
It's for them to open.
That they agreed to pay me and take themselves. Therefore, nothing much survives there.
Their case has to be opened by them, not by the respondent. Every day we have to tell that. Yes.
Please, Your Lordship. But please have the short chronology. But on 13th of March 1967, when Hydraulics and Pneumatics India Private Limited was incorporated.
Yes.
But in fact, the point is very short. As you know, only the facts are there. The point is very short. Even notes plot will not be. I've given exhaustive interest.
Okay.
Please see, on 4th of July 2012, a notification is issued under Section 4 of the Land Acquisition Act by Respondent to State, intending to acquire a portion adventuring 15,276.25 square yards situated at so and so. 6th notification is issued, Lord, in December 2012. Award is passed, and Lord, entire compensation of the endeavor award was received by the petitioner without any competing claims from any individual partner. On 22nd June 2003, original LLP agreement was executed, and the petitioner was converted, not from a company, we converted ourselves into a LLP from a private limited company. 2014, Lord, we filed, that is the petitioner LLP files a reference under Section 18 claiming for enhancement. Then, Lord, the original LLP was amended inter alia, increasing the capital contribution of Aniruddha Kumar. That is not to 11.33%. Aniruddha Kumar, Lord, is not the respondent. Your Lordship may note that he is not the respondent. I will show who the respondent is. As per respondent number 1, which is Matalar, an unsigned supplementary agreement was allegedly executed showing R1, that is Matalar, as a partner of the petitioner, LLP. The same was bogus, invalid, wholly unenforceable. As per the invalid LLP agreement, Aniruddha Kumar purportedly transferred his 11.33 shareholding in the petitioner LLP to R1 Matalar. The invalid LLP agreement was not signed by 2 out of the 7 partners of the petitioner LLP and is therefore invalid under clause 21 of the original LLP agreement. In the meantime, in 2019, the reference court award passed by the reference court, enhancing the compensation at the rate of rupees 70,000 per square yard. After making deduction towards development charges, etc., the amount was enhanced to 56,000 per square yard. An appeal is filed on 19th of March by the petitioner LLP. We filed against the reference court award, inter alia seeking enhancement of compensation. He is not there in the picture, he doesn't do anything. Then an execution petition LAC so and so is filed. LLP for the execution of the reference court award. Order passed by executing court, inter alia issuing notice on the execution petition. Now, this is important from this date. 11th of February 2021, respondent number 1 filed the metal arc application under Order 21 Rule 15(2) of the CPC before the execution court. In the metal arc application, it was claimed that metal arc is a partner of the petitioner. LLP is relying upon the 2018 unsigned agreement, para 2, having acquired the share of Aniruddha Kumar. Aniruddha Kumar, my lord, has 11.33, we don't dispute. Appeal, now, my lord, 7th of October, appeal being referenced so and so is filed by the respondent number 2. State, my lord, goes in appeal to the High Court, challenging that particular reference award. In 22-23, Aniruddha Kumar.
He files an application under 21.
15.
What has happened to that application?
Dismissed. That is dismissed. Because he's not a degree holder. Against that plot, High Court interferes. And because the High Court interferes, we have come here before the lordship.
But you have not said that in your note that it is dismissed.
I was going through the dates because it came to be dismissed subsequently. Serial number 18 plot. In 23, it came to be dismissed. Therefore I am not.
But if it came to be dismissed in 23, how is the RFA filed in 21?
No, RFA is filed. Not 21 RFA is filed by the respondent number 2. State. State blood challenges the announcement given by the reference book. And now you have come here before your lordships also. So that is my thing.
State is also.
State has come because High Court further announced it. And High Court further announced it, and that is what is talking about 300 crores, as if the state is going to give us tomorrow. That also we are fighting. Against that, Lord, they have taken time in the High Court in that execution, saying that contempt, saying that we are before the Supreme Court. Incidentally, that matter is coming up before your lordship. So, Lord, now this is important. 22-23. Aniruddha Kumar. Lord, this is very interesting. Please see this. Aniruddha Kumar simultaneously filed numerous petitions, applications in his own name, claiming himself and not R1 Metlar to be a partner of the petitioner, LLP, and seeking identical relief as the Metlar application. Company petition, now these are the various things brought in files. Company petition dated 29 January under section 43 of the LLP Act before the NCLT, alleging operation and mismanagement by other partners of the petitioner. 2. Impleadment application bearing number so and so filed by the petitioner in so and so LLP before the Honorable Court, High Court. So he files before the High Court also. And 3rd, impleadment application dated 4th October 23 bearing CM number so and so filed in HP in the Himachal High Court blood for appeal. Now, 6th of April 23, this is important, execution court passed an order dismissing the Metlar application filed under order 21 rule 15.2 of the CPC. But holding that Metlar is neither a degree holder nor he has been there in any of the proceedings. Now, Lord, against this, 12th of April 23, CR number so and so revision was filed by the respondent number 1, that is Metlar, against the Metlar order. 29th November 23, Lord, High Court passed the interim order. Ignoring the principles of Bacha Culture, what the High Court does is, they says that yes, he is a joint degree holder. Number 2, every partner is a joint degree holder. Some law laid down by the High Court, every partner is a joint degree holder. 2, it says go into the question of that agreement which is produced by him, whether the invalid agreement, whether Metlar or not, Aniruddha is a partner. Now, despite Aniruddha having himself gone earlier, saying that I am the partner, whoever, he has no problem, Aniruddha is our partner. Now, Lord, please see the next. Your lordships, Lord, entertained after we filed an SLP on 14 December and was pleased to stay the order. After this, Lord, on 21st December, order is passed by the execution court in execution petition, recording the factum of mental arc application being withdrawn. Now, please see, he withdraws his application. Lord, in fact, the whole proceeding should come to an end once he withdraws the application. Mental arc withdraws the application, and a fresh application under order 21 rule 15.2 having been filed on behalf of Aniruddha Kumar, seeking identical reliefs as the Metlar application, thereby admitting that R1 Metlar is not a partner of the petitioner. Then, Lord, 11th of January, order is passed by the Honorable High Court recording the impleadment application filed by Aniruddha Kumar to be dismissed as withdrawn in view of Aniruddha Kumar having filed a similar application before the execution court. The High Court says you go before the execution court. The second impleadment application bearing CM number so and so is also filed, Lord, in the civil revision seeking the same relief. Now, Lord, judgment passed by the Honorable High Court in the state's appeal now. This is important. The state's appeal not in the meantime comes before High Court. And the state of Haryana is directed to make payment within 3 months. It is announced and Lord State is passed, directed to pass. Then Lord order passed by the Honorable High Court inter alia recording that CR number so and so, that is of Anil Kumar, is to be dismissed and withdrawn by the petitioner in view of the judgment in RFA having been pronounced along with the direction upon the state of Haryana to make the payment. Accordingly, second increment application. My learned friend Lord referring to that 300 crores which we are going to get is this particular announcement which the High Court has granted. Against that announcement, Lord, an appeal has been filed by the state and which is not coming before your lordship. SLP is filed. Now, this order, Lord.
Now, let us say the orders passed by the executing court.
Yes, yes.
Rejecting his application
Correct.
and the order passed.
No, that's and one more. Lord, please see the order which is passed by the executive court. Page 254, Lord, in the compilation.
In the SLP.
Lord, in the SLP. Page 254, in section 340. Now, Lord, it is important. This application stands withdrawn. On this which the order is passed, application stands withdrawn. Because metal are.
After rejection, it is withdrawn.
No, after this and after matter is pending before your lordships. Stay is granted of the deputy order, then he goes and withdraws it. Metal are saying now Aniruddha Kumar is coming in front.
No, but after his application is rejected.
Rejected. It goes to
revision
is filed by the High Court.
in the High Court.
High Court not remands the matter back, setting aside the execution court's order. Against that, we come before your lordships. Your lordships entertain the Supreme Lord and stay the order. In between, he goes, and that is the date which I read. He goes and withdraws that application. And Aniruddha files an application. Please see my dates, Lord. Please see the dates. Note serial number 21.
Yes.
14th of December, your lordships granted stay. Your lordships get that one. 14th of December, number 20. Number 21.
No, but once,
December, order
once his application is rejected, and in the remand, whether that order is set aside.
No. Which one?
No, whether this order at page 254.
That is set aside by the High Court.
By the High Court.
Which is stayed by your lordship.
Yes.
Setting aside of that order, it's stayed by your lordship.
Let us see the operative part.
Yes.
And when is it withdrawn otherwise?
21st of December.
So it is
That is
subsequent.
number 21.
Then the SNP has become an infrastructure.
Exactly. SLP has become infrastructure. Point of law is to be kept open.
Where is that order of 21st of?
Yes, not, this is what I think he will be. That's the same one. Same one. Let's just see this order. Yeah, that's right. Para 10.4 of the order so reads as follows. At this stage, now Lord, please see bit below. At this stage, learned counsel for the applicant, Messrs. Metala, by his separately recorded statement, has withdrawn his application dated 11 February under order so and so. In view of the statement, the said application is dismissed as withdrawn. Not once this withdrawal comes, the whole things become infructuous.
So you withdraw your SLP?
No, only thing High Court order has to go. High Court order has to go.
No.
It says, the High Court order says, partner is a degree holder, joint degree holder. And further says, you decide on that bogus agreement. Therefore, if that order goes, not in view of this dismissal, the High Court order has to go. Otherwise, it will become a precedent and shown everywhere for law.
That original application is
Gone. Therefore, nothing remains in the proceeding. This High Court order has to go.
whatever that Aniruddha Kumar has a right, he may put.
Yes, right.
Yes. And Aniruddha Kumar is not a party here.
Is
Is he or not?
Seeking to impede. Now seeking to impede. But how do you come with such bogus pleas?
Take my counter for a moment. I tell you what, I'll now, just take my counter for a moment.
Counter of metal art.
Metal art, that's it. And before that, just see page 20, imputed order, page 20. Imputed order, page 20 first. Well, page 20 in the imputed order first. In the SL. Right at the top minutes.
Yes.
This is a clause in the LLP. No partner shall, without the consent of all the other designated partners, obtain in writing for that purpose, transfer his interest in the LLP by mortgage, sale or otherwise. Now just see minutes for a moment, page 101 of the FLP.
No. So whether the rights which were given to you by Aniruddha Kumar.
So minutes, I'll tell you, Roshan.
No. Is there a consent by all the other partners?
Now.
Yes or no?
So minutes, by designated partners, yes. Please see my count. Your Worship saw designated partners.
Yes.
Now just come back a previous page also, minutes to the previous page 19. Page 19.
Yes.
I'll tell you, Worship, what they are doing. Metlark is a partner.
First, tell us the order
Yes.
and how do you justify that order? That's all.
But now let's first see page 19 at the bottom.
Yes.
No person may be introduced as a new partner without consent of all existing partners, such as incoming partner shall give his prior consents also. Then the page over.
So whether metal art, when it is entered as a partner, is there a consent of all the partners?
So Metlark is a partner. I'm
Whether metal art is claiming now.
So I'll tell you, Lordship, Metlark is where I'm a partner and my wife is a partner. Their designated partners allow that. That is annexed to my counter affidavit.
Let us say clause 21, no person may be introduced. Anyway, we will not go into that settlement agreement is valid or not.
That's a separate thing. Just kindly now see page 20 again. Page 20.
Yes.
No partner shall, without the consent of all other designated partners, obtained in writing for that purpose, transfer his interest. So where one partner is transferring to another, then designated partners have to give consent. Now please see my counter affidavit, page 46.
No, so therefore, even Aniruddha, if he wanted to transfer his shares to Middle R, he could not have done it without the consent of other parties.
Designated partners give consent. Now let's page 46. Designated partners.
That is a question to be decided by the executing court.
I tell you what is happening. Well, let's do things. Number one.
Every day we have to remind.
Every
day, every hour. Your matter and Mr. Nidesh Gupta starts as a respondent arguing the case.
Well, it's today when Metlark went to the executing court pursuant to designated partner.
How can you go back to Goa for some vacation and sit in that court for some time?
Or Bombay. Or Bombay or Nagpur.
Or Bombay.
Then the habit is a little angry.
I learned with this even Punjab and Haryana also.
Now, what happens is this. Designated partners allow Anirudh to move his 11.33 to Metlark.
Now you have withdrawn your application.
I'm saying something.
Please answer the query. You have withdrawn your application.
Yes. Because they were creating a problem.
So what did it be? Let the executing court decide Aniruddha's application in accordance with law.
Now, I'm saying this.
Once you are having withdrawn application, what right do you have to?
I'm saying, may I just answer that? Why did I do that first? Just in one sentence. Because they were objecting to Metlark after designated partners gave approval. I said, all right, you forget this controversy. Anirudh in any case has 11.3.
So therefore, Aniruddha's application will be decided.
Now your Lordship will see your Lordship's two orders where they said, we don't have a problem in Anirudh getting his 11.33 and they've given it to me after the expenses have been deducted. So this whole controversy of whether a partner can get or not, well, it's under order 21 rule 15. one degree holder coming on behalf of all of them is the issue. They have all taken the money. Now, Millet, whether I was allowed to or not, they agreed, yes, you can take. I need to see the order again, Millet.
Yes, Aniruddha can take.
So, Millet, I am therefore.
You are not appealing for Aniruddha, you are appealing for Metal Arts.
I am also paying for Aniruddha. My application for implement is also filed here. Where I am saying, if they object to Metal Art, the transfer is banned. Aniruddha, in any case, you accept. Aniruddha is also before your lordship. I am appealing for Aniruddha as well.
Is he a party?
Well, it's he. Infringement application is there before your lordship.
Is he a respondent?
Well, he's
Was he there before the revisional court?
Well, it's,
Again,
no. Well, it's,
why don't you be comfortable on the seats? If the chairs are not available, we'll call for the chairs.
well, it's because they are. Well, in essence,
Now let Aniruddha prosecute his application before the
would
executive.
your lordship consider this? Since the money has already been disbursed,
The present petition challenges the order passed by the revisional court, thereby allowing the revision filed by the respondent number 1 herein. No, respondent number 3 herein. No, sorry, you are respondent number 1.
Metal Arc is this.
Respondent number 1 herein. Correct. The facts in the case are not in dispute. The land owned by the petitioner company, which was earlier a private limited company, was acquired first by notification dated 4th of July 2012 under section by notification under section 4 of Land Acquisition Act dated 4th of July 2012. The section 6 notification of the said act came to issue on 31st of December 2012. The award came to be passed on 29th of May 2013. Subsequently, the original LLP agreement was executed. The petitioner company was converted into the limited liability partnership into LLP from a private limited company. The petitioner LLP filed a land acquisition case number 4 of 2014 challenging the award passed by the LAO dated 29th of May 2013. The reference court passed an award on 20th of December 2019, enhancing the compensation at the rate of rupees 70,000 per square yard. An appeal being RFR number 2352 of 2021 was filed by the petitioner LLP challenging the reference court award. It appears that for execution of the award passed by the reference court, the petitioner filed an execution petition before the executing court. Notice was issued in the said execution proceedings on 31st of August 2022. Paragraph. It appears that in the meantime, the respondent number 1 hearing had entered into an supplementary agreement showing R1 Metal Arc as a partner of the petitioner, having acquired 11.33 shareholding from basis of the said agreement, the respondent number 1 filed an application under Order 21, Rule 15(2) of the CPC before the learned executing court. First, the learned executing court holding that the LLP was having a separate entity. It was a juristic person distinct from shareholders, and the shareholder did not have any independent right over the company's assets. Observing that, the application filed by the respondent number 1 came to be rejected. Being agreed thereby, a revision came to be filed by the respondent number 1 herein.
Yeah.
You may correct us when we are wrong. At least don't correct us when we are right. Paragraph. The learned revisional court held that the award was in the nature of a joint decree, conferring the right and creating the rights in favor of all the partners in the LLP firm. As such, the respondent 1 was entitled to invoke the provisions of Order 21, Rule 15(2) so as to protect their interest in the award. First, the executive court, therefore, the reference court, therefore, remanded the matter to the executive court to give an opportunity to all the parties to produce all the relevant documents as regards the execution of the supplementary agreement dated 17th of December 2018. Paragraph. Sri Nadkarni, the learned senior counsel appearing on behalf of the petitioner, submitted that the appellant Kalyan, the learned revisional court had grossly erred in interfering with the well-reasoned judgment and order passed by the learned revisional court, the learned executing court. It is submitted that the order passed by the revisional court was based by the executing court was based on the judgment of this court in the case of Pacha F. Guzar versus CIT, reported in 1955, 1 SCR 876. Further submitted that the supplementary agreement itself is a bogus agreement, being unsigned, 1, and therefore not enforceable in law. First, Sri Nadkarni fairly concedes that insofar as the original partner Aniruddha is concerned, same position is not disputed. The position is not disputed that he has 11.33% shareholding. Post. Paragraph. Sri Gupta, the learned senior counsel, appearing on behalf of the metal arc, submit that the learned executing court has rightly remanded the matter. Learned revisional court has rightly remanded the matter to the executing court for considering an appraisal. Post. He further submitted that the petitioners have withdrawn the entire amount deposited by the state government, and as such, if no orders are passed by this court, the petitioners, the respondent number 1 would be left with no remedy. Paragraph.
11.33 was deposited here.
Yeah.
11.33 was deposited in this court, out of which a certain part is given rest.
He further submitted that out of the 11.33 deposited for this court, certain amount is already paid to the in the name of
Aniruddha.
paid in the name of Aniruddha. He therefore submitted that the remaining amount is also required to be paid to Anirudh. The Gupta also appears on behalf of the said Anirudh, who has filed an implement application. Post paragraph. A subsequent, this court is required to take a note of subsequent developments. After this court entertained the proceedings and granted stay on 14th of December 2023. The present respondent over filed an application before the executing court, thereby withdrawing an application on behalf of the metal arc. A fresh application was filed under Order 21-15-2 of the CPC on behalf of the Aniruddha Kumar. Faced with this situation, confronted with this situation, the Nidesh Gupta, the learned senior counsel, submitted that since the petitioners were opposing the application of metal arc, the Aniruddha was left with no other alternative than to file an application. Paragraph. It appears that according to the Gupta, the respondent number 1 hearing and the said Aniruddha Kumar are two sides of the same coin. Paragraph. However, we cannot ignore the fact that after revision was allowed by the learned revisional court and the matter was remanded, the respondent number 1 has withdrawn an application. In that view of the matter, when there is no application on behalf of the respondent number 1 pending before the learned executing court, the order passed by the executing court in favor of the respondent number 1 is totally rendered infructuous. Paragraph. In that view of the matter, we find that the present petition, the SLB itself does not survive and is disposed of. Paragraph. Insofar as the application of the said Aniruddha Kumar is concerned, we direct the learned trial executing court to consider the same in accordance with law after giving an opportunity to all the parties. The amount which is deposited in this court be remitted back to the executing court for passing appropriate orders in accordance with law. We further clarify that none of the observations in the impugn order passed by the revisional court would be taken into consideration by the learned executing court while passing the order on the application of.
May I just say something on that? That court has taken on merits. The Honorable High Court says here that each of the partners is entitled to the decree amount. Your Lordship need not set aside that part because they have themselves, in pursuance of this.
We are keeping all questions open, whatever is the law, because the revisional court has relied on the and Aniruddha is not before us.
I'm saying something. That part I bow down to that. Insofar as the partners withdrawing their pro rata share is concerned, your Lordship's permitted that each of them has got their share. That is the part on merits which the High Court holds. If your Lordship sets that part aside, then I go back to argue the question of law merits. That question.
Yeah, therefore we have kept all the questions open.
Your Lordship may kindly consider we have already withdrawn. So that part has become infructuous. That question.
You have withdrawn 3 crores. What has to be happened to the remaining amount that the executive court will decide?
They say the question of law may not be disturbed.
But there are just 2 things which I want to.
You are appearing for whom? How many matters are there?
Lord, may I just make.
We don't permit 2 counsels to appear for one party.
Lord, there are just 2 things which I want to point out. At one place, your Lordships have said 70,000. 70,000 was the enhancement. After deduction, 56,000.
70,000.
And at one place.
After deduction, it was 56,000.
And at one place, instead of the revisional court, your Lordships have said reference.
That Mr. Gupta corrected us.
After that.
We will correct it, yes.
That's
the earlier part of.
That's already been done. The High Court order be set aside.
We have said that it no more survives. So if his application doesn't survive, then the order passed in his favor also doesn't survive. Your application would have taken a longer time.
Somebody advised them, well, I don't know who advised them, my Leonard friend was not there at that time and they would do that.
But the executing court will decide about the money that your lordship.
That you already said.
Expenditure.
We have said all questions kept open, but let the executing court decide.
And would your lordship put a time, let them decide in 2 months, 3 months?
No.
As expeditiously.
Implement, dispose of.
And will it expeditiously?
Decided expeditiously.
Yes, Lord.
Along with that, they will annex your bills and all that. We are having one matter here against one of the senior councils.
When I saw 3.47 crores in less than 2 months, I thought I should be on that.
That was not in the Supreme Court. That was for 10 years litigation. No, not 10 years.
Anyway, next matter.
Have they called the next matter?
Yes. Your lordship. May it please.
May it please, Lordships, Your Lords.
Can I request your lordship with item number 52? I filed a IA on behalf of one of the students that may also be taken up along with this matter. Lordship, can I give
I have a shortcut.
Yes.
I think Mr. Venugopal is aware.
I am
of it. Plant has given.
I am appearing for the petitioner, my lords.
With all the questions which are in contest.
My lords, so far as the petitioner is concerned,
Yes, Mr. Venugopal.
she stands high up and gets to is number 22 in the original list, which has now been interfered with by the High Court Division Bench. If she is 22, my lord, since her ambition in life is to get into the NLSUI Bangalore, she would get it. But with the changes made by the High Court, she is now very doubtful as to whether she may be able to get into NLSUI or not. Now, there are two issues on which this is important. And if your lordships will take my paper book at page 179, question number 67, they give, my lords, the basis of the question. And they start by saying, the second paragraph, in regard to unless rejected by a party, this contract will remain valid and enforceable. A party who is at a disadvantage due to any circumstance applicable to the contract has the ability to render the agreement void. That is an option. Then the query is at the bottom, an agreement made by an adult but involving a minor child, where the signatory is a minor child himself. This agreement would be A, valid and enforceable agreement, B, a voidable agreement. The valid and enforceable agreement on the face of it cannot be the correct answer. And so far as the petitioner is concerned, she gave my lord a B, a voidable agreement. Now, if your lordship would look at page 180, and in the middle, the syllabus is set out as a guideline. You will not require any prior knowledge of law to attempt the questions in this section. You will benefit from a general awareness of contemporary legal and moral issues to better apply general principles or propositions to the given fact scenarios. Therefore, not pure law, but a question of general awareness of contemporary legal and moral issues. And thereafter, my lord, if your lordships will come to the underlined, identify and infer the rules and principles set out in the passage. Apply such rules and principles to various fact situations. Understanding how changes to the rules and principles may alter their application to various. Therefore, my lord, it's a question of common sense and inference. And my client answered a voidable agreement correctly. Now, the High Court says, no, to answer this question, you should know law. And law cannot be the basis of the queries and the answers. And therefore has removed the 1 mark, which all of us have got, as a result of which I lose 1 mark. And even losing 1 mark would change the entire conspectus of my lord, the ability to enter into the college of your choice. And therefore, my lords, the submission which is made is that nobody would answer that a minor, that child, they don't know what is the age of the child even, would be a valid and enforceable agreement. Now, so far as, my lords, the consortium is concerned, in the counter affidavit which they have filed, which, my lord, is at page 10 of the counter affidavit, B, question number 77.
Just 1 minute. Counter is on top.
Or shall be shown.
This is fine. This is not the.
High Court.
No, here, in the Supreme Court, filed by the consortium, respondent, the only respondent in my petition.
Do we have, do we have copies? So it's not here. Might be, maybe you have filed it late or something.
Our stand is encapsulated in a table. So they are giving that booklet.
That you can give it to us.
Very well, Lord.
You must be supporting the petitioner here.
They are supporting the petition. Lordships may take page 2 of this booklet which they are running over. The master query 77 is query 67 so far as yes, set A is concerned. I am set A. And there, my lord, the last column, DB ruling is incorrect. Legal reasoning is within the prescribed syllabus. Only law is not. Legal reasoning implies that candidates must infer legal principles from the passage given to them and answer the question posed to them on the basis of such principles. No prior knowledge of law is expected.
No, let us see that again, that passage, which is that page.
That's at page 179.
179 of the main paper.
First, my lords, at the top,
It's 179.
shall I read from the top, my lords?
No, we can ask Mr. Sanganaran too.
I just read. I don't believe the first paragraph is overtly relevant. It might be the second paragraph. Okay, I'll read the whole of it. The Contract Act deals with contract law in India, its rights, duties, and exceptions arising out of it. Section 2H of the Act gives us the definition of a contract, which is simply an agreement enforceable by law. To understand the difference between void agreements and voidable contracts, it is important to talk about sections so and so of the Indian Contract Act. Void agreements are fundamentally invalid, making them unenforceable by default. These agreements cannot be fulfilled as they consist of illegal elements and they cannot be enforced even after subjecting it to both parties. However, in the case of voidable contract, the agreement is initially enforceable, but it is later on denied at the option of either of the parties due to various reasons. Unless rejected by a party, this contract will remain valid and enforceable. The party who is at the disadvantage, please mark this is what you emphasize, due to any circumstance applicable to the contract, has the ability to render the agreement void. A void agreement is void ab initio, making it impossible to rectify any defects in it, while voidable contracts can be rectified. In case of a void agreement, neither of the parties is subject to any compensation for any loss, but voidable contracts have some revenue. A valid agreement.
One minute.
Yes.
Dates.
Yes.
When was the NCLAT examination held?
December.
December.
December 24.
1st December 2024.
When were the results declared?
Hmm.
Immediately, within a week.
On 2nd of December, there was a list which was published, whereafter objections were invited. Objections had to be given by the 3rd. Objections were given, and then there was a committee which was formed, and then there was an oversight committee, and thereafter the final list was circulated of the answer.
I think the question is about the answers rather than the answer key or the.
No. When was the
declaration of results? Declaration of results, I think the 8th of December. But that answer is.
And when were the petitions filed?
From 10th December onwards. On 10th December, there's writ petition 17138, which is Aditya Singh versus Clark, which was filed in the Delhi High Court. And then thereafter, many petitions in Delhi High Court.
And what is the reasoning given by the High Court?
As far as the chart will show, they say it requires legal knowledge, prior legal knowledge.
How many questions were the subject matter of the various petitions?
17 in total.
Yes.
17 in total. Ultimately, well, only 4 were indicted.
Which are those?
Your Lordship will have.
One is 77.
Question 5, 77, 115 and 116.
5 is which?
Your Lordship has my violation.
Yes.
It was the first page.
Which among the following is not a trade or occupation? Representing the pathway running through the town hall path. What was the?
There is no challenge to this, and in fact, we have accepted this.
Addition.
There was an error. In fact, there was an error in our understanding, and the key is wrong. So we've accepted it.
Okay.
And there is no challenge on this. 77.
So this question has been deleted.
Yes. Answer is changed. Answer is changed.
Answer is changed.
Depending upon whoever has answered it correctly.
Just for clarity, Mr. Venugopal, I am concerned with questions 77 and 116.
No, but when we are looking at the larger.
larger.
That's my table on the right side. The last column is really the consortium stand post the DB's order. And your Lordship will note the consortium has not challenged the DB's order. It was done largely because of the fact that we had an internal meeting. We moved an application before the High Court. Place our position for one question or a modification because we felt that the benefit should have been given to everybody else. But because your Lordships were seized with the matter, we are before your Lordships. The other reason was we have to do 5 rounds of counseling, and we have effectively 4 weeks to do that now. That was the reason. But since we are before your Lordships, there is an error and we are accepting that.
77 DB ruling is incorrect. Legal reasoning is within the.
Yes, sir. So this also.
The High Court judgment is at page 22.
Yes.
Of my paper book.
Mr. Venugopal.
Yes, my lord.
Now, as I think he has tabled all them. So let us go by that table. Yes. So now, which is the other question?
Yes, question 77 is the next question, which is what Mr. Venugopal was referring
to.
That's done. Then please have the third question.
Where is the next question?
78 at page 4. Yes.
Question.
The
next question is 109.
Mr. Venugopal, I think you let Mr. Rao take us through all the questions.
Very well, my lords. Let him do that.
Yes.
Then page 6, which is logical reasoning, question 88.
Which of the following scenario?
This the learned single judge had in fact held that the answer was wrong.
So this
inadequate.
This also you are accepting.
You accepted the DB's judgment, subject to whatever somebody else has to say.
Yes. So you are affected basically with which questions? You only tell us that.
Today, as far as 115.
No, you are not affected according to the CLAD.
Yes.
The DB has gone wrong on which questions?
77, it was wrong.
Yes, that you are.
The standard of the petition. And 115, because of the error in one set, we just have that in page 7.
This sort of consortium you have? Those vice chancellors, all learned vice chancellors sitting together, calling themselves academicians of the highest repute.
May I tell your lordships, in fact, from 2006, Professor Shamnath Bashir's petition is pending here. Each year, there are mistakes in the clan. Each year, it goes on rotation from university to university and they're incapable of doing it. Therefore,
Why don't
this is your lordship's order, which is passed regarding this very issue. They were supposed to, the ministry was supposed to step in and take steps. This is one more round which took. We have dealt with the matter only from the standpoint of how best to compensate candidates who lost conduct. The commission was given the task of conducting the examination was duty bound to ensure facilities of uninterrupted UPS and generator. Record indicates complete inadequacy at that point. We therefore direct Union of India and the Ministry of HRD to appoint a committee to look into the appropriate remedial measures, including penal action, if any, against the body which was entrusted with the task. The committee so constituted shall also look into the aspect of having completely satisfactory arrangements in future so that no such instances are repeated or reoccur in coming years. We must also observe that the idea of entrusting the task of monitoring the conduct of entire exam to different law universities every year also needs to be revisited. The agreement with the examination conducting body, which is placed on record, indicates that as against the amount made over to such examination conducting body, the fees charged from the candidates are far in excess. The committee shall bestow consideration to all these aspects after having inputs from such sources as it may deem appropriate, including BCI, and make a detailed report to this court within 3 months from today. The office report suggests that this sealed recover report has come to this court and it is pending. So at some point,
first we'll deal with the immediate issue.
Yes.
But then you have to implement. Why can't there be a permanent mechanism like a NEET or triple?
Secretariat. That's in fact.
The person who's a permanent person is the secretary, and your lordships would consider that. Your lordship is right. There has to be some continuity and some oversight. So that would be done under your lordship.
In fact, for completion, these are the prayers in petition 600 of 2015. I've extracted the prayers.
Yes, that we'll consider.
Yes, just so your lordship. Just see in that the prayer B. Mandamus to constitute independent professional permanent body tasked with conducting CLAT on an annual basis. This is 2015. And every year we have kept on filing.
What is the Union of India doing after that?
That report is coming after which they will.
Who is happening for Union of India?
They're not parties.
They're not parties here.
So in fact, have this next week and have the Union of India so that.
No, I will have them next week, but what about the immediate problem?
So this will be problem.
So you take us to the other question according to me.
Not the first, only 115, the rest and 116, just if you're not sure, just have the impugned order. But it page, please just have my convenience compilation. When it's 115, we make a concession at page 7.
115 is.
Extends that to everybody, irrespective of who is my convenience compilation. Could just page 7 compilation.
Page 7.
Yes.
Yes.
According to the paper setter and as per the provisional answer, the answer was A. Because the oversight committee does not review it. The single judge was not seized with this. The division bench finds that D is the answer. We also make a concession. What the division bench goes ahead to do is to say, because you have said that the correct answer is not A but D, marks should be given to all candidates irrespective of whether they have attempted it or not. That is the only place where it's effectively then giving place marks. So that is the concession. The concession has effectively been taken beyond what was the concession. Our concession was only with regard to the answer. It was not that marks be given to them.
If the wage is paid to men working in agricultural sector, 35 on an average, what is the amount of wages paid to women in
this was it's a mathematical equation that we had to do, and the question was formulated wrong. What is the amount of wages?
Which vice chancellors are framing this question?
Yes, there is a problem. There are some other problems which we also flagged during the course. We've given our feedback, and perhaps they've taken that, and the lordship will find that perhaps it should not be as we shouldn't have these. Ultimately, we are dealing with children's lives and there is a great cloud of uncertainty as a result.